I think all of us here, regardless of political stripe, would agree that ensuring rigorous controls of Canada's border helps to instill confidence in the immigration system, and I think also helps to prevent the rise of nationalist rhetoric, as we've seen south of the border. So my questions are going to be in that context. We heard this week that the IRB is at a 40,000 case backlog, which is incredible. So obviously we need to have any means possible to ensure that the spirit of the Safe Third Country Agreement is being pursued. It's been noted that when the Safe Third Country Agreement was negotiated in 2002, there were several loopholes that were allowed. And, frankly, they're being used today to thwart the spirit of the agreement by people who are entering Canada illegally from the U.S. and then making asylum claims. A previous colleague of mine, who was the immigration minister, stated that he repeatedly asked the Obama administration to amend the Safe Third Country Agreement to remove the loopholes. Yes, he also has stated that they completely refused to consider any changes. Yesterday, I noted that he speculated that this was because the U.S. government regards it as being in their interest that a certain number of illegal aliens self-deport themselves to Canada so that the U.S. doesn't have to worry about tracking, detaining, or deporting them. I'm not asking you to comment on that, but I'm wondering if the government has broached the topic of amending the Safe Third Country Agreement to cover claims made by people entering Canada through unofficial points of entry with the new American administration, especially as we A, renegotiate NAFTA, and B, I think it could be argued that it would be hypocritical for the Americans to ask Canada to improve border security if they are not willing to reciprocate. Or is the government content to allow the new administration a convenient option to encourage people to self-deport to our country with a minimum amount of American resources involved?
I'd like to just begin by saying that we in no way encourage irregular migration. If your question is about Canada becoming sort of like a second option for people who have exhausted their options or feel that they've exhausted their options.
Just to clarify, my comment is whether or not the government has broached with the Americans the renegotiation of the Safe Third Country Agreement.
We haven't done that.
Thank you.
At the moment.
My next question is on related to the IRCC document entitled Ministerial Opinions on Danger to the Public Nature and Severity of the Acts Committed and Danger to Security of Canada. It outlines how the minister can exercise authority to deem someone who is seeking asylum protection or has already received the same in the event that they can commit an egregious act against the safety of Canadians and designate them a public risk and subsequently order their removal from Canada. Per this document, I request that you and your officials table with the committee the number of times since November 2015 that the CBSA has advised clients that the CBSA will seek the minister's opinions on the basis of paragraph 115.2a and paragraph 115.2b or combined of IRPA, as well as how many removal orders have been issued subsequent to reviewing these opinions, as well as the number of outstanding deportations associated with removal orders.
We're happy to table that document with this committee.
My question is then subsequently related to the information sharing agreements and processes related to that process and other processes between hearing asylum claims and ensuring the safety of Canada. The current law stipulates that institutions can share information if it's relevant to the recipient's institution's jurisdictions or responsibilities under an Act of Parliament or another lawful authority in respect of activities that undermine the, quote, the security of Canada, including the respect of their detection, identification, analysis, prevention, investigation, or disruption. My understanding is that if Bill C-59 comes into force, the Government of Canada institutions will only be permitted to share information that contributes to the recipient's institution's carrying out of his responsibilities. Has an analysis been done on how Bill C-59 will affect the minister's abilities to carry out the responsibilities outlined in ENF 28?
All of the implications of existing and proposed future legislation have been very carefully analyzed.
Could you table that analysis with the committee?
Well, I'll ask the department to.
And specifically, I'm asking for the analysis on how Bill C-59 will affect the carrying out of duties in ENF 28. Will that be tabled with committee?
I will examine what's available and get back to the committee, Mr. Chair,
I will remind you that you do have an obligation under Bosch and O'Brien to provide the committee with information requested here.
I will do my very best to respond fulsomely, as I always do.
Happy birthday, and I'll turn that over to Mr. McGuire.
Yeah, thanks to my colleague. The CBSA target stated that the 80% of the failed asylum seekers would be out of Canada within 1 year. And the departmental performance report, though, shows that 53% of those failed asylum seekers are still in Canada past that particular time frame. So given this failure, that these failed asylum seekers are still in Canada and haven't been removed or left on their own, how many of these failed asylum seekers have slipped through the cracks and the government has no idea where they're presently located?
Mr. Cloutier, can you offer some perspective on the removal process?
Thank you, Minister.
Well, we know what the removal process is. I just wondered if the government has any idea of where these people are.
Thank you, Mr. Chair. Generally speaking, we do everything that we can in order to effect the removals as quickly as possible, and that is our obligation under the law. There are a series of factors that would impede this, including our ability to obtain travel documents, confirmation of other factors, making arrangements with the countries.
Can you table the number that might be that you might not know where they are or slip through the cracks? I mean, we know the process and that sort of thing from this side. We just wanted to know if you've determined where all of these people are at the present time. If you can just table that information for us.
Mr. Chair, we will provide a document outlining our approach to this, indeed.
But can you give us a number as to how many you don't know where they are?
So, Mr. Chair, I understand the question that's being asked. I think in order to answer that question properly, we need to go back to the way the system of removals work. We have, at any given time, a removal inventory of about 15,000 people. Our priority is always to deal with national security concerns, to deal with people with serious criminality, and the second tier.
Mr. Chair. Again, to cite Bosch and O'Brien around the requirements of witnesses to answer questions, my colleague has asked a very specific question, which is, according to the department performance report, they have not met their targets for deportations, and he is asking how many people, I believe, the government is not aware of their whereabouts, and he is asking for that information to be tabled to committee. I would just ask that you remind the witness under this particular clause that he is required to submit this information to committee.
Welcome to the committee, and you have 5 minutes.
Thank you, Mr. Chair, and thank you to the ministers and your officials for coming. Mr. Minister Goodale, it's our understanding that, and this is from frontline CBSA officers, who, by the way, are worried about talking to MPs for fear of losing their job, have indicated that the normal initial process in dealing with regular asylum seekers usually takes about 8 hours. This is the initial process. Mm-hmm. But these same CBSA officers are now saying that the processing time for illegal border crossing initially has dropped to 1.5 to 2 hours. So that drastic reduction in initial processing time leaves Canadians to wonder what is being cut out of the process to deal with these illegal border crossing. Can you provide an explanation as to what you are not doing now that you would normally do for the legal border crossers that you're not doing? What have you cut?
Mr. Chair, I have, through this whole process, over the last number of months, constantly sought advice from CBSA about how to handle the volume that they have to deal with in a timely way and in a way that does not, in any manner, short-circuit the security issues that need to be dealt with. And I have been assured repeatedly by the CBSA that there is no compromise on security. They have internally reallocated resources in order to make sure they have the personnel with the right skill and talent at the various border points that need that attention. They work seamlessly with the RCMP, and the RCMP have also reallocated resources into the areas that are most affected. CBSA, the RCMP, and the government have been absolutely vigilant to ensure that the security process was not compromised. And by the way, let me just say about if you're hearing a CBSA officer that says he's somehow reluctant to speak to a member of Parliament, he or she need not have any such reluctance. They are citizens of this country, and they're entitled to speak to their members of Parliament.
So basically, what I'm hearing is that some processes have been cut, and that the priority remains the security of Canadians to bring people in. So processes have been cut. Could you please provide in writing, or the CBSA department, to this committee at your earliest convenience, what processes actually have been cut, and we can move on.
I can provide. Your question implies some degradation of services.
No,
that implication is just not appropriate. I will provide a description of how we have coped with the volume in a way that processes that volume efficiently and does not compromise on safety and security. And any implication to the contrary is simply inaccurate.
So, and then with that explanation, the difference between how illegal border crosses are being processed now compared to the regular ones that were done before would be a good comparison. Thank you. So it's our understanding that in the shortened process, what's happening now is people who cross the border illegally are conducted only with a basic criminal history check, criminal records check, and fingerprinted. After that, they are told they can go, and the meeting is adjourned to a secondary meeting at some point. The asylum seekers asked to come back for a secondary meeting. These CBSA officer we spoke to are telling us that some of these asylum seekers, as we said, are not showing up for the secondary hearings. So if that's the case, how do we know where they are, who they are, and what's happening with that whole process, and how many are not attending these particular hearings? Do we have any numbers on that?
In the secondary hearing, I presume you're referring to is the IRCC interview,
the follow-up
that determines whether or not they are then eligible to go before the IRB.
Can you, and I just, given the limited time, Mr. Minister, I apologize. Can you just table those numbers for us? That would be great. So my last question would be, so how does the government propose to deal with this serious issue of people not coming back for their secondary interviews? And what's their plan to restore public confidence in our ability to secure our border, to make sure that and mitigate the concerns for public safety for those that come in through a process that is illegal and don't follow the process as they should?
We have 17 seconds.
Mr. Chair, we will examine all of these questions very carefully to make sure that we provide every bit of information we possibly can in response to the inquiries from various members of Parliament. But let me just say, the implication in this dump of innuendos that somehow the border is insecure and somehow the safety of the country is being compromised is absolutely wrong.
Thank you, Minister. Mr. Tabera, we have about